Welcome to the Libertarian Counterpoint. I'm Richard Field. On the program today we have Kevin Duell, Secretary of the Libertarian Party of California and an intern at Pacific Legal Foundation, former Ron Paul supporter back in 2008 and 2012.
Yes.
And Students for Liberty activist. Also, John Cameron, author of Rewire and Re-Kill, and a development officer at PLF. Welcome to the show. The Pacific Legal Foundation won a unanimous United States Supreme Court victory. 8 justices voted for the 8th time to make PLF victorious. Tell us about Hawks, Army Corps of Engineers versus Hawks. Kevin?
Right. So facts of the case deals with I think up in Minnesota, peat farm operation. The Army Corps of Engineers was asked to give a determination of whether that land was a wetland. If it was a wetland, it would be regulated under the Clean Water Act. And when the Army Corps of Engineers did make that determination that it was in fact a wetland, even though it had been used commercially for peat extraction, our client, Hawks, the Hawks company, looked to appeal that decision in the courts. And that case was then brought to the court, was remanded back down to the, I believe, to the Army Corps of Engineers, was then appealed up to the U.S. Supreme Court, where the court, as you mentioned, found unanimously that in fact the judicial determination that the land was a wetland was appealable to the courts.
As opposed to administratively within the Army Corps.
Right.
So the choice of the Hawks company prior to the ruling was to either face civil charges of some, thousands of dollars per day and criminal penalties, or spend $200,000-300,000 for in the application process to do a peat mine in a wetland, which of course would be turned down anyway. So
or to lose their business as a third option.
Yeah, or just give it up.
Well, and not only that, but when you say appeal, I don't think that makes people aware of the full weight of it. Typically, those appeals take over 600 days.
To the Army Corps, you mean?
To the Army Corps.
Yeah.
Over 600 days and over $250,000, and the appeal is made to the same person generally who made the original determination that it was subject to federal jurisdiction under the Clean Water Act. So that's kind of like asking the burglar who broke into your home whether he wants to have a second set of keys, because there's no way they're going to find against their original determination. So you go through that whole process to have the same person who originally said no say no again. And before, people were stuck until this case, and now they're not. Now they can do judicial review, and it's wonderful.
Which means get out of the administrative review process and go straight to the federal district court and get a judge to listen to you.
The other great thing about that case was some of the things that the justices said about, one was it Kennedy that said that he didn't really think that private property rights were being observed by the process that they were using. What did he say specifically? I wish I had the quote in front of me. It was something about.
He was questioning the viability of the whole EPA underlying statute, as far because basically calling it unconstitutionally vague, because they define waters of the United States as anything that's ever wet. Which means, and they have a new ruling that came down.
That's self-defined by them, whereas the original act said navigable waters.
Yeah, the original act was relatively clear. Navigable waters meaning something that you could float a boat in, or at least a canoe. But now they're saying anything that is a tributary to a navigable water, or wetland that is close to a tributary to a navigable water. And in this particular case, the peat deposit was 120 miles away
from the closest
navigable water, that mighty river, the Red River of the North. So it was obviously a bureaucratic overreach by the Army Corps of Engineers. What surprises me to a certain extent is, the Hawks Company won in the 8th Circuit Court of Appeals in Minnesota. And it was the Army Corps of Engineers that appealed. because they didn't want it to stand at the circuit
And
court
the
level.
Obama administration supported that appeal, and they were all behind it.
Well, yeah. And the other interesting thing about the case is there were dozens of amicus cases filed by various states, by various trade organizations, farmers groups, and so forth, on the PLF side, on the Hawks side. And I don't think there were any amicus at all on the government side. Is that correct?
I'm not sure about that, but
Okay.
You would think that, Sierra Club and
No, they
Woolly Beaver Friends and
they knew a
Tree
loser.
Huggers of America.
They knew a loser when they saw one.
Well,
I think.
and what's surprising is that's the other thing that when you look at these cases, that the praetorian, the people in power that are employed by the government are so disconnected from reality that they're willing to spend millions of dollars of taxpayer money chasing these rabbits. I mean,
Well,
it's just
yeah,
crazy.
I mean, this is, if you take a look at the Supreme Court record of the Obama administration, other than Obamacare, he's lost and lost badly on just about every case that he's had to defend against, whether it's Murr, whether it's Coons, whether it's Sackett. Hey, those are all PLF cases. It's
Imagine
interesting,
that.
Yeah.
well, I mean, I think that really comes down to the overreach of the administrative state. It's pretty clear. Now, in the oral arguments, though, for the Hawks case, I was actually most impressed with what arguments were made for the other side. Kagan, particularly during oral arguments, seemed to really indicate that she was going to be siding with the government on this. I was surprised that she actually voted with everyone else in the unanimous decision.
And not only that, but there was unqualified. I'm using not the right legal term. It was unqualified on her part, whereas Ginsburg's the only one that
just a little bit.
cast any doubt
That's
at
right.
all.
That's right.
And
only through the form of
and that's only
concurring
when
part
she
with the opinion.
woke up. So, stopped napping, went back to sleep.
So, I mean, it seemed in the oral arguments that the main thing that the other justices, the justices that weren't automatically sold, were kind of grappling with was the distinction between, and a very clear distinction between Reed Hopper, who was the one arguing the case,
For PLF.
right, was making between judicial determination, which for all intents and purposes does serve that, does have the finality of, an agency, telling you what the law is going to be, what the
Jurisdictional
implications are going to be.
determination.
That's right.
Yeah.
Where the issue the justices like Kagan were bringing up and really getting stuck on was the difference between that and a mere opinion letter.
Well, yeah, and that was the very disingenuous defense offered by the Corps of Engineers. They were saying, well, this is not really a final agency action. I mean, we can sue you and throw you in prison if you violate it, but it's not final. It's only advisory. We're just giving you our friendly opinion on what we think the situation is. And so, but it's not final. It's not final. The only way you'll find out if it's final is if you refuse to obey our friendly advice, and at that point, we'll throw you in jail.
And I
It's
think
like the cop suggesting to you when he's got his Glock out, aimed at you, put your hands over your head.
You may want to put your hands over
you
your
may
head.
want to put your hands over.
Because if you put them over your head and raise a single digit, there's a good chance you're going to get shot. So yeah, it was bureaucratic, slick obfuscation and facile. What's the word I can say on camera? Facile fertilizer.
Yes.
How about that? Yeah.
And I think it's really that fundamental unfairness is why ultimately there was a unanimous decision in favor of the Hawks, the Hawks company. Because
And the Kent is even more crazily unfair.
The what?
The Kent recycling versus the Army.
Right,
Corps.
we're set up for the Kent now. Tell us a little bit how Hawks sets up the Kent recycling case.
I mean, the fundamental issue in Kent Recycling Company is whether such determinations are appealable, whether there's
Right.
judicial.
The same issue.
It's the same issue, right?
Yeah.
So, although the Supreme Court declined the petition earlier this year, or was it this year or last year, for a hearing, I think the expectation is that they will be giving a favorable judgment and taking the petition now that the issue has been basically decided in the Hawks case.
And there's a point to the Kent case which is particularly disturbing. There's a rule in the Clean Water Act that land that was formerly agricultural land can't be considered as a wetland unless it has been abandoned so long that it is actually returned to a wetland state, if it ever was to start with. Because a lot of farmland is drained. We used to call them swamps, now we call them wetlands. So if the ground has been unworked and abandoned for so long that it returns to that state, then it is under the jurisdiction of the
EPA.
federal government, of the EPA, as a wetland. However, the EPA or the Corps put out a proclamation, I believe, and changed the rules midstream on the Kents, because the land the Kents want to use basically as a landfill or a dump site was former agricultural land that hadn't returned to a wetland. So it should have been, according to their own rules, immune from their jurisdiction as a wetland. But they changed rules in midstream a few years ago and said, we've now done this proclamation, and even though the law says this, we're going to say it no longer says that. So they didn't even pass a rule or a regulation or have it reviewed by anybody. They just woke up one day and said, "I have spoken," and the rules are changed. And so that makes Kent recycling probably even more insidious than the hawks.
Yeah, it's interesting how regulatory law tends to kind of ignore the underlying statutory law. We saw that in the Johnson case as well, where the Clean Water Act specifically exempts stock ponds from regulation. And Andy Johnson built a stock pond and was told by the Army Corps that you're going to have to pay $35,000 to $70,000 a day fine until you tear the thing down.
His problem was he built too pretty a stock pond. If he'd have built an ugly stock pond, they would have been okay with it. But
the ducks liked it too much.
He built a pretty stock pond, and I guess they saw it as a swimming pool or something. I don't know. Yeah.
Well, I think that the problem there actually comes from the deference courts give generally to administrative agencies.
Well spoken. Yeah.
Which brings up the nomination of Merrick Garland. I don't think there is a federal circuit judge that's more deferential to agency discretion than Merrick Garland. If there is, I'm not sure who his name is.
So,
Mao Zedong.
Mao
Zedong.
The next up at the United States Supreme Court comes up in October, where it'll be Murr versus St. Croix County, Wisconsin. Tell us what's at stake there.
Sure. So this goes to the question of when you're trying to determine whether the government's taken your property. Actually, to take a step back, Fifth Amendment requires that when the government takes your property, it has to be for public use. You have to be given just compensation. The challenge is often trying to determine what you're going to include in the analysis for what's been taken. Going back to Penn Central, which is one of the Supreme Court case that establishes kind of the modern test for determining whether there's been a taking. In that case, the court in a roundabout way refers and puts in some language about what's the parcel as a whole. A line of cases since Penn Central interpreted that to mean that when trying to figure out whether the government's taken your property or not, you have to consider the whole parcel and nothing short of the whole parcel. So the challenge in the Murr case, our client's parents purchased a piece of vacation a lot on the St. Croix River for their family to be able to enjoy. They subsequently purchased a adjacent lot as an investment piece of property. On the vacation lot, they built a vacation home and enjoyed that for a generation. Now, at this point, the children of the parents are now looking to sell the investment property in order to be able to repair and upgrade their original vacation lot. Now, the issue comes from the fact that several years ago, the local county passed an ordinance on setback requirements. Now, the setback requirements paired with an ordinance on minimum project size means that neither of these two independent parcels with independent deeds, right? Neither of them are large enough to actually be built on. So when the children of the Murrs wanted to sell the property, that is the investment piece of property, in order to repair their vacation piece of property, the county told them that they weren't going to be allowed to, and that if they wanted to sell the investment piece of property, they would have to sell their vacation home along with it. So this, these facts just very, very beautifully set up this parcel as a whole question. Because from the government's argument, the parcel as a whole, because these two pieces of property are contiguous, there's no, line in the dirt, painted in the dirt between them. Because they're contiguous, the county and the state of Wisconsin is arguing that they are in fact the same parcel. They are two halves of a whole.
Relevant parcel.
The relevant parcel, right. So, and really, I think these facts, set up the case better than anything else could. And I think PLF should be, very grateful that the client, the Murrs, stepped forward, willing to challenge the county on this. Because, in most cases, you're not able to have it set up as clearly with it, being done as well. I mean, they never developed the investment piece of property. They kept it as a separate piece.
And paid $80,000 in property taxes on it,
Over the
I
years.
believe, over the years. Yeah.
That's as a buildable lot.
Yeah.
Right.
Yeah.
Yeah.
And the law that changed the setback and changed the zoning or the lot size requirements had a grandfather clause in, saying that it did not affect the original the original platted out lots.
Right.
So
And both of those lots were purchased long enough ago.
yeah, and they were
to
purchased
be
independently.
grandfathered.
They were purchased independently.
So, and
1 3 years after the other.
Here's my take on it as well. If the lots were, if the other lot was owned by anybody else and bought at the same time, it could be developed. But because it's owned by the Murrs, it's almost as if the local government is saying, well, rich folks who can afford 2 lots are going to be punished and only allowed to develop one of them. And the other one is basically going to be wasted space, and we're just going to take all the economic value, which goes back to the takings clause in the Constitution. And if the lots were 50 miles apart,
Wouldn't
the
even need
rules,
to be.
it wouldn't even apply. But because they're next to each other, that's the parcel as a whole and relevant. And I don't know how many, do you have any idea how many cases of this nature there are throughout the states? Thousands? Hundreds at least throughout the U.S.
I mean, if they're not litigated, the issue comes up a lot. I mean, because under the point with, I mentioned Penn Central and the Penn Central test. I mean, the issue with Penn Central is when you're trying to determine whether there was a taking or not, all the factors that you're going to be taking into account all depend on what the size of the parcel is. So if it's twice as large.
And the government folks have decided that parcel as a whole includes not only that parcels, but all other contiguous parcels to talk about parcel as a whole, where I'm almost certain if you'd asked anybody who did the original Penn Central thing, even though the language might not have been crystal clear, parcel means freaking parcel, folks. If you're paying separate taxes on it and it has a separate parcel number, it's a separate parcel. But, it's being read a different way. Anyway.
Those are 2 property rights cases. Another area of law, of course, for PLF is right to earn a living. Arty Vogt is having a problem. He can earn a living in Virginia, but not in West Virginia. What's the deal?
So he runs a moving company based in
Furniture movie?
Yes.
Okay.
So moving homes when people want to move from one place to another, and on the his business is based on the West Virginia border in Virginia.
Okay.
A lot of his employees live in West Virginia. A lot of his friends live in West Virginia. But say if a friend or family or even one of his employees wanted to hire his business to move them even to Virginia, he would not be able to because of a competitor's veto law in West Virginia that allows businesses in West Virginia to preclude businesses in adjacent states from being able to compete.
How does that work? How does that work? Competitors veto. How does that actually work in terms of the way the law is written and the way it's implemented?
From what I understand, it's regulatory. Where
Okay, so you've got a regulatory agency that has the power to admit people into the moving business or not admit them.
And they consult with the businesses in
And
the state.
is this a case of regulatory capture, where the industry regulated has captured the agency that does the regulating and is saying, I think we've got enough moving van companies in West Virginia, we're not going to allow anybody else in? Is that essentially what's happening?
Well, normally we talk about regulatory capture as something unintentional, but this was intentional.
Well,
This is the way the law was structured.
It's not necessarily unintentional, intentional, unintentional, whatever. It's set up in such a way that the regulatory agency is populated by people who are being regulated, one way or another.
Yeah, no, it's institutional
You mean
regulatory
like
capture
the
then.
Contractor State License Board?
Yeah, like that,
And
like
the
that.
Bar, oh no, wait.
Oh, we can't talk about the Bar Association.
The American Medical Association and...
Self-regulating and with the power to say, we don't want any more damn competitors in this market. We're doing just fine ourselves, and we don't want to have price competition or anything nasty like that.
Yeah, and to point out, besides the fact in these facts that there is no major moving company in that area of West Virginia.
So, in other words, if you live in that particular area of West Virginia, God forbid, you would have to go to Charlottesville to get or to you have to go to a town, Charleston, a town 100 miles away in order to find somebody to move you.
Yeah, something like that.
Wow.
But
So
West
what's
Virginia is a nice place.
Yeah,
Let's be
West
nice to West Virginia. You people used to be able to dig coal out of West Virginia. And
Not anymore.
now,
That's a lot of
apparently, coal is evil,
Yeah.
folks. Yeah. It's cheap. It's in the ground.
So what's the history of winning cases like that with PLF? Regulatory veto cases.
But you tell me, guys.
Oh, okay. Well, I mean, this is what
He
the fourth
didn't know he was going to.
the four-
He's out of school now. He didn't know he was going to have to face the exam.
fourth or fifth case that PLF has taken on moving company regulatory
And-
vetoes.
and
The first
Richard-
one,
Are you serious?
Richard,
the first one was in Oregon, where
what would be the record of PLF in these?
we've won them all, as far as I
Okay.
know. Yeah. First one was in Oregon, where a couple of college students bought a moving van and said, "Let's do Moving Is Us" or something like that. And the state of Oregon very wisely reacted to the publicity in the case and said, "Let's repeal that law." This is kind of embarrassing. It went to. There's been a case in Kentucky where they actually won it in court, and there are cases in Montana and Nevada and other states as well. So it's an interesting area of law, making it possible for companies, small entrepreneurial companies, to not be precluded from going into business because their competitors don't want any competition. Healthcare has been a big issue ever since Obamacare, and of course, many, many decades before that. I mean, the health care insurance problem goes back to World War II, when price controls made it necessary, or made it advisable for companies to offer free health care in order to hire better employees because they couldn't give them an actual raise. But anyway, we have a situation now where health care is highly regulated, and under Obamacare, it's just a whole mishmash of rules and regulations and problems, where it looks like United Healthcare actually has made the announcement that they're not going to do business in California under the Obamacare regime anymore. Anybody have any thoughts on where this is all going to end up?
Well, I always have thoughts.
Of course you do.
Sometimes about things I've never even heard of. In this case, I have a little bit of information. The guy running whatever it's called in California, ObamaCare California, makes $339,000 with his 24% raise that he just got. Lee, his last name's Lee, and his parents were heavily involved in the whole Medicare thing. They've been his parents, the whole family, that generation, physicians, and they've been basically socializing medicine in the U.S. for generations. Now, he has come out and said that United Healthcare is not pulling out because it's not viable for them. They're pulling out because they're not good at running their business and they set their rates wrong. Now, United Healthcare is the largest healthcare provider in the country, and has turned a pretty good profit for its shareholders for an awfully long time. So I'm kind of shocked that somebody who's living with their trotters in the trough on the public dole has the gumption to say they're not leaving because it's not a viable marketplace. They're leaving because they're bad at running their business. They're just really good at running it everywhere else, but bad at running it in California. So an awful lot of major healthcare providers are pulling out of California. And if anybody could move their hospitals, which are kind of hard to do because they're big and it's hard to move them, they'd be leaving California too. So this is just other evidence that Obamacare is already dying.
Well, and United is moving out of other markets as well as California.
Yeah, I think they're pulling out of 30 some odd markets out of the health, whatever they call them,
health insurance, the exchanges,
the pools and exchanges. Yeah, they're pulling out of those because they can't make any money.
Yeah,
and the guy said flat out, we want to help people, but we can't afford to lose money everywhere. And California is one of those everywhere.
Which, of course, raises the question, how do you pay for health care if you don't have government-sponsored health care? And it's really, really extremely elementarily simple. You pay for it out of pocket unless it's a major medical expense, and you get insurance for a major medical expense. You get insurance for something that costs more than you can afford to pay on an annual, ongoing basis.
Major medical.
Major medical, 10,000 or more, 5,000 or more, whatever it is that you can afford. You buy a low-cost insurance policy to cover some catastrophic illness or catastrophic injury. Other than that, you pay out of pocket, and you know up front when you go to the doctor's office what you're going to pay. You don't pay $5 and think that's all you're paying, or 20 or 30. You don't see the bill normally when you go to a doctor's office under health care, and if you do, you don't care because you're only paying $25, $30. That's the problem with health care. It's not. There's no market. There's no incentive for doctors or hospitals or other healthcare providers to do any kind of competition at all.
The incentive is there, but it's for the people in the healthcare business to make a ton of money, and it's basically a monopoly system, and it's prepaid healthcare. It's not health insurance. And back in the day, you were talking about 40 years ago, 50 years ago, where everybody did what you're talking about. Healthcare costs were a much smaller percentage of GDP. And they actually weren't rising faster than GDP growth in other areas.
That's all the time we have for the show this week. We'll see you again next week, same time, same place on Libertarian Counterpoint, and looking forward to it. We're on the internet at www.accesssacramento.org, on YouTube, on Channel 17 in Sacramento, and on cable channels all over the place. Check your local listings for time and channel. Thank you very much. See you next week.